Welcome, everyone, to the first show in the new year. Thanks for joining us, and a wonderful 2023 to everyone. We are honored to have the first members of the Judiciary on our show, the Honourable Judge Rose Raven. Welcome, Judge Raven. And the Honourable Judge Ellen Gordon. Welcome, Judge Gordon. One purpose of the show is diversity of roles in the profession. And clearly, judging fits that purpose. We all knew when our parents said we should be lawyers when we argued with them and talked back to them. But I can't recall a parent ever suggesting their child be a judge. I don't think that children are that impartial or that well behaved. And I've never heard a child ask what they wanted to be when they grow up, answer to be a judge. So the desire must come from elsewhere. And I'll ask both of you about that later on in the show. Judge Raven, you joined the bench in 1996. And before that, what was it that drew you to practicing in the area of family law and child protection?
First of all, thank you, Jeff, for inviting me on the show. And I'd like to thank the audience for sharing their lunch hour with us today. What caused me to practice family law? I graduated at a very young age, and I came from Manitoba, arrived in British Columbia, did not have a lot of contacts in the legal community here, set up my own shop, and I'm going to say that I fell into the practice of family law. Because then, even though it was a long time ago, like now, there was still a lot of work, and people just walked in the door looking for that kind of service. So I became busy as a sole practitioner early on practicing family law, and then there was an opportunity to take up a contract to do work in child protection, and I did that for the Surrey region for 15 years. Okay. So that's how it happened, and there wasn't a lot of time to do other things, even though I was interested in doing civil work like real estate, wills and estates, which I did do some of because it's a spin-off from family, as you can imagine, having practiced family law for many years yourself.
How did your first conveyance work out?
I had a really good conveyancer, and it was great.
Okay. The numbers added up, Judge?
Yes.
Okay. And Judge Gordon, you joined the bench some 20 years ago or so?
2004, yes, the end of 2004.
Before that, what drew you to the practice of criminal law?
Okay, like Rose, I'm from Winnipeg. I'm not as smart as Rose, though, because I stayed and practiced in Winnipeg for a period of time. And I articled at a boutique litigation firm, so I knew I wanted to litigate, and I just fell in love with defense. Just loved it. I didn't think that there could have been a better, more honorable career.
What was it about you that fell in love with defense?
I think I liked protecting the little person from the power of the state. Seriously.
Okay. Mm-hmm. And when did you both know that you wanted to join the bench?
I'll jump in on that one because, to be perfectly honest, I never thought that I would ever be a judge. And I would never have put in my own application. I was approached by at least 2 different judges over a period of 3 years before I even applied. And it was their confidence in me that led me to bring the application.
I have a somewhat similar experience. I was doing a long murder trial with a lawyer who was on judicial counsel. And when we finished the trial, he approached me and said, "I think you'd be fabulous. I'd like you to apply."
Do you remember the qualities that each of you had that you believe that you make a good judge? I'm going to just name some here. Okay?
Okay.
All right. These are the perfect qualities of a judge. I know you both.
Well, Rose has them. I'm not so sure about me.
No, yeah. I think
judicial virtue, modesty, gentleness, awareness of your fallibility, attentiveness to your power, and handling the burdens of judgment. Did you feel you had the capacity for any of those qualities or had any of those qualities?
I don't think I really thought of those things at the time that I applied. I saw being a judge more as being a service to the community, a community that had been very good to me, had supported me throughout my entire practice, and I wanted to sit in the community where I had worked and to hear cases involving people from that community, if possible, to help them solve their problems and to give back. That was where I was coming from.
Okay.
I thought, in terms of one of them, I thought, I'm a good listener. I can listen and retain. And I thought compassion for the people who come before the court, no matter what their need is probably what I thought would make me want to be a judge or be a good judge.
Is that difficult to maintain?
You would think it would be, but frequently you have people before you and you think, I've never heard a story this tragic. And I can think of, over the years, 5 or 10 people that have absolutely broken my heart. So even if you go a year where you may have people who are less deserving of your empathy or your sympathy, you'll get one of those people. And life has been so cruel to them, and everything that has happened to them has been so horrific. If you can do anything to encourage them, anything to say, let's see how we can make your life better, the job is worthwhile.
The former Chief Justice of Canada, Beverly McLaughlin, said in a 2004 paper, the judge does not have all the answers. The judge is not a high priest with a direct line to heaven, down which the right answers come tumbling. The judge is a human being. She is learned in the law. She possesses, we hope, qualities of experience, patience, empathy, character, and sound judgment. But she nevertheless is a human being exercising a human function. Do those words ring a bell?
Oh, absolutely.
Tell us a bit more about that.
You want to go?
Well, I'm just trying to think of what I would say in response to that. Justice McLaughlin is an amazing woman, an amazing jurist, and she's an inspiration to all of us. And what she says is absolutely true. When every case that you hear is challenging because no two cases are the same. And so the judge is challenged every day to apply the law to that particular set of facts. And it can be very difficult, and the result may not always be what the general public thinks is appropriate. And so the judge has to be strong enough and independent enough to apply that law, regardless of what the public might think.
Judge Raven, does that fit in with the issue and the problem of isolationism when you make a judgment that you may not be popular? Is that when somebody says to you the job is somewhat isolated?
It could be. I rendered a decision many years ago, and the media referred to me as a clown in that particular case because it was a very unpopular decision where I did not send a young person to prison. And you just have to be able to take that kind of criticism from the media and from the public if they think that the decision is wrong. We have a process in our courts. If the decision is wrong in law, it should be appealed, and then another court can review it and determine the rightness or wrongness of it. So in that respect, you do make your decision alone. Even though you can talk to colleagues and get some advice, the decision is yours and you live with it.
And Judge Gordon, what do you say about Her Ladyship's words that judging is nevertheless a function of a human being and exercising a human function?
Well, I think that she was getting at two things. The first was when she said we're not a high priest. One thing, we're not omniscient. So people think that maybe we can just cull through a case and go, oh, he's lying, she's telling the truth. No, you can't. We're not omniscient. We just have to do the best with the tools that we're provided. But the other thing is, as Rose says, sometimes we do make mistakes because humans make mistakes, but we try not to. We try to be fair. So as long as you, in the end of the day, believe that what you did was the fair thing to do, even if others may think you were wrong, it's an exercise in human judgment. And doing it properly is doing it fairly, whether people think it's correct or not. And you can always appeal us.
It sounds like a very difficult job, particularly when you're having a bad day that we all have. So when counsel are difficult or uncivil, or when a witness cannot be controlled, or when a self-represented person is yelling at you, which they do from time to time, what do you do? How do you handle that?
I had one day where a voir dire was argued in front of me, and I ruled against the Crown. And this is when I worked in Surrey, so I had a long drive home. And I was driving home and I realized I was wrong. And I was furious with myself. I ate a pint of ice cream, standing up. And then I decided I'm going to call them in and say I was wrong. And I invited the defense to seek a mistrial because clearly there might be an apprehension of bias at that point against me. But I had to rectify it. So the ice cream helped in my decision. And that's what I did. But you do have bad days, and you have to go home and think them through when you're more calm and figure out a way to try to get it right.
What I try to do in those situations, and we do have a lot of situations like that, particularly in the provincial court with self-represented litigants, is take a deep breath and recognize that this trial that was scheduled for 1 or 2 days is going to take 5 or 6. Because either I have to take the time to deal calmly with these individuals, or I'm going to rise to their anger, and there's going to be a yelling, screaming match in the courtroom. And I don't know how helpful that's going to be to anyone. So I know I tend to take more time, and others may feel differently about that.
Getting back to what Judge Gordon was talking about, I would find it very difficult not to be second guessing my decisions all the time, particularly when life, liberty, and family is at stake. I'd find it very difficult. I'd lose sleep. I wouldn't know what to do. I would feel isolated. I don't know how to handle that kind of thing. And you must both be very experienced at that kind of thing.
I think we're more fortunate in terms of the isolation because not only did we both work in the Surrey region, and now we both work in the Vancouver region, there's lots of judges. So if we're at all nervous before we render reasons, like I just had a case where I actually spoke to the chief before I rendered reasons. There's always someone. And we have friends and family and a legal community here of our former friends. So we're not isolated. But for judges who sit in smaller communities, yes, that might be horrific.
The other thing I think the Provincial Court of British Columbia has done very well is education. So when I was appointed in 1996, there was no education for new judges. So I was told, this is your list in Chilliwack. You start on Monday, find your way there, and do whatever it is that you're given. And it was a steep learning curve, and it was scary. But now, new judges get a lot of training and education, and they get mentors on the bench. They get to watch other judges judge before they start judging themselves. And we've also started a criminal boot camp for those judges appointed who don't have a background in criminal law, and a family law boot camp for those appointed who don't have that much of a background in family law. And even if you do have that background, it tells that part of the education process in these boot camps is to show judges what they can do in difficult situations, like how to handle those difficult litigants. And then there are committees. So the family boot camp and the criminal law boot camp have judges that teach them and prepare the materials. And they also act as a resource for any judges in the province. If you have a problem with a particular case, you can get them on speed dial, or you can email or text them, and generally there will be a response. So that type of resource is now available even to judges that sit in more remote locations. It's not right next door in the coffee room or the next door chambers, but it's there electronically. I see a real improvement over the past 20 years in that area.
We were talking about civility and uncivility. What do you do in the courtroom when counsel are being uncivil to each other? How do you deal with that?
Sometimes I just tell them that we have to take a break and stand down. It's not an easy thing to deal with, though, from my perspective, because I'm conscious that if there's two lawyers, for example, that are arguing with each other, their clients are sitting behind them, watching them, and paying for their services. And if I start perhaps showing that I think one of the lawyers is misbehaving rather than the other one, I sometimes worry that the litigants are going to perceive me as being biased against them. And so I'm very, very careful, and I try to deal with it delicately. I doubt that I have ever called a lawyer out. If there's any out there that say I have, it'll be interesting. But I try to avoid that in the courtroom because I'm very aware of who is there and who is watching.
I have to say, because I mostly sit in criminal courts, and the criminal bar, Crown and defense, fortunately in this province have great respect for one another, and certainly outside of the court are, unlike other provinces, friendly with one another. So I haven't had that experience where I've had to say, this person is doing something so bad that I need to take a break. So there's civility in the criminal bar, fortunately.
Yeah. Judge Raven, I was struck in some of the comments that you sent to me before the show for me to review, and I was struck by some of the principles that you learned growing up in an Italian immigrant family of 7 children in Beausejour, Manitoba. And here's where some of the principles. All you need is love. Don't ask me to sing that song. The roads in Canada are not paved in gold. Mm-hmm. Anyone can accomplish their goals if they really want to. And you can put a positive spin on almost anything. You know, I point these out because so many children in child protection cases may never have the benefit of these positive principles while growing up. And do you reflect on any of that when you have that kind of situation before you?
I try to say something very positive to every young person who appears before me, and in particular to any child that I interview, because it's my view that these are individuals who are disadvantaged for a number of reasons. And I really do try to send the message that if they want to do something, what do they want to be when they grow up? And just because they're poor or from a certain ethnic background or have got have disadvantages in their youth doesn't mean that they can't accomplish their dream. This is an incredible country, and I really want to encourage all of the young people that come here from other countries as refugees, as immigrants, to know that they can accomplish and be a judge in this country if they want to be. And I am reminded of a lunchtime talk I did with children at the Surrey courthouse, because we were a teaching courthouse. And they happened to be primarily children of color, and some of their parents came as supervisors. It was a local school. And when I asked for questions, the father stood up and looked at me and he said, I've been in every courtroom here, and all I see is white judges. Do you need to be white to be a judge in Canada? Oh. That was the question that he asked me. And that would have been about 10 years ago now. And so how do you respond to that other than to say, of course not, and we're doing a better job, but we can do better?
I know that when you sat in Surrey for 20 years, you were given the name, because of all this, the Surrey Optimist, because you believe that every person can be redeemed. But having seen so many child protection cases, don't you get despondent sometimes that children may not get the love, the opportunities, and the resources to reach the goals that you set out in your principles? Mm-hmm. Does it feel frustrating sometimes that you can't offer them that?
Well, definitely there's a frustration knowing that we cannot solve the problems that all of these children face, and even more so the youth that come before us in criminal justice courts. But I've never felt despondent about it. I have continued over 25 years, and I'll continue for the future to encourage every young person that I see to make the best that they can out of their life, do what they want to do.
I believe, and I may be wrong, that during our tenure in the profession, the United Nations Committee on the Rights of Children gave the right of all children under 18 to be heard and taken seriously, and that this is a fundamental value. How has that, Judge Raven, right developed on a practical basis, on an everyday basis, in your courtroom?
We are educating a lot of people, including judges, on the rights that children have to be heard. And I am particularly proud of the young people that I have met who have been survivors of the family justice system in British Columbia and have now, as young adults, taken on the role of speaking at education conferences and in particular addressing judges about how they felt they were not heard and how they had a right to be heard and wanted to be heard and involved. So, on a practical basis, in every family law case, I do try to address the issue up front at the beginning to say to lawyers, if you have a child issue in your case, are you thinking about how that voice is going to be heard? Address it at the beginning of the dispute coming before the court, not in the middle, and try not to do it during the trial, because we still see a lot of that. These issues are coming up and in the middle of the trial, and then there's a tremendous delay if there has to be somebody interviewing the child or even the judge interviewing the child. This is something that needs to be addressed early on.
Okay, so address it as, quote unquote, a housekeeping matter at the beginning of the trial.
At least lawyers should be addressing their minds to it. Okay. How are they bringing that voice forward? And there's a number of ways to do it.
But that's a great tip for young counsel.
I would really appreciate it if young counsel did that, if all counsel did that in a disputed family matter before me, where who is going to be parenting the child, parenting time, guardianship, and contact time are big issues. We're at a time now where most people recognize that we have to hear the voice of the child. It's part of the best interest test under Section 37, and we need to be taking a little bit more time, care, and attention as to how we go about doing that.
Judge Gordon, I sat in the gallery of your courtroom a number of years ago, as I did yours, Judge Raven, and I left despondent, I must say. I left despondent after seeing the poor, and I left despondent after seeing the mentally ill and the physically challenged and the homeless and the addicted appear before you. I just thought I was in the wrong place. And I saw the frustration of all the players in the courtroom, prosecutor, defense counsel, and the court in these circumstances. And I wondered whether there was any legal remedy that was fair in those circumstances. Rehabilitation seemed really difficult to obtain. Deterrence seemed academic. Restitution impossible. And the person charged seemed to be needed to be served by the community, not provide community service to others. That's how I felt leaving that courtroom, that this wasn't the place. And I didn't know, I think I talked to you a bit about this afterwards. Do you have any thoughts on that?
I can assure you that it's often not the place. And the worst situation we get, and it's not infrequent at 222 Main Street, is an individual has some form of mental illness and commits a crime. And the prosecution seeks their detention on a bail hearing, essentially because of the mental illness. And sometimes you have people without a criminal record who that happens to. And, well, let's put it this way. Mental illness doesn't fall neatly into any of the grounds that we can detain someone, the primary, secondary, or tertiary grounds. And I'll often say to defense counsel, I can't detain your client because I'm not detaining someone for being mentally ill, but you have to give me something. You have to find a place this person can go to, however temporarily. You have to find an individual who can perhaps direct your client to appear in court, help your client appear in court. The resources are lacking. And while I'm not suggesting that individuals who fall short of being not criminally responsible ought not to be prosecuted, we as a community owe them a lot more than we give them. And if we're going to prosecute, we have to, as you say, address the rehabilitation issue on the other side. We can't just let this go on forever.
Judge, do you have any comments about that? You see this too.
Well, I'm just trying to think in terms of what I could add to it. I don't know if the public realizes that when someone comes before the court and they appear to be mentally ill, that sometimes they're held in custody while there is a psychiatric evaluation to determine whether they are legally fit to stand trial. And I recently presided over a situation where a young woman facing a very minor offense, literally of taking items from a Value Village store, had been detained for weeks in custody, awaiting a psychiatric evaluation. So the reasonable average person looking at this would say, this person needs medical assistance, not a jail cell. How we get there is a very good question. It is clearly a matter of resources and where we as a society want to put our resources and funding. So we see that, and it's not that uncommon. A lot of people who come before the provincial court in criminal cases have mental health issues and or drug addiction. Those are the two primary underlying reasons they actually come into conflict with the criminal justice system in the court that we sit in.
My difficulty would be balancing fairness and empathy with protecting the public from further harm. Is that something you have to think about all the time?
All the time. So that's why you have to try to fashion probationary conditions which will assist the person in finding housing, assist the person in either getting treatment or continuing treatment. So fortunately, one thing we have in Vancouver is an ACT team, assertive community something team. And I just can't think of what the T stands for. And they're wonderful, wonderful people who work on the downtown east side. And sadly, if your corner is, I don't know, Columbia and Hastings, they will find you and ensure that you go see your physician and get the shot you need for your health concerns. And assertive community, sorry, I just can't think of the T, but they're wonderful. And you have to ensure that the closest mental health and medical center, and there are a number of clinics that offer both, to where the person lives or stays or couch surfs, or sometimes some people prefer to be outside, they're afraid to be inside, where their corner is, that they can get treatment there, and that they know that probation services, or VSU, which is a more active probation service in the downtown east side, can help them. And we have, if you help someone, you're protecting society, because it's not as if these people wake up in the morning and say, oh, I'm going to commit a crime. I'm happily committing crime. That isn't what happens. Often they're driven by addiction or mental health or both. And even if the services aren't full, we have to make sure that the services are available to them.
I think in fairness as well to our court has established a number of specialty courts, much more on the criminal law side than in the family area, and that is to try to problem solve. For example, the downtown community court, the drug court, the domestic violence courts, the Indigenous courts, of which there are many now throughout the province, trying to develop ways to deal with these issues in a non-adversarial and helpful method. And I just want to mention, because I had a conversation recently with one of my retired colleagues, that today is the 6th year anniversary of the Aboriginal Family Case Conference Court in New Westminster, which is the only one of its kind that I'm aware of in the province of British Columbia, where Indigenous families who have had children removed from the Ministry of Child and Family Development can meet with elders, and the judge plays a much more of a listening type of a role and try to work on a plan to have their children returned to their care. And if anybody's interested in finding out more about that, one of our judges who sits there, Judge Anya Brown, has an 8-minute video on the Provincial Court website that you can watch, and it's very informative. So there's an effort that's being made within the court to try to address some of these issues.
As Judge Raven was called the Optimist, you, Judge Gordon, were sometimes nicknamed Auntie Ellen, I understand, because of your encouragement of young counsel, which is laudatory. And I want to know from both of you, for the audience is watching, what tips you have, what are the most important tips you would have for young counsel in your courtroom?
In terms of a trial, know that case backwards and forwards. If you want to cross-examine a police officer on, let's say it's a charter issue, have his notes memorized, have his reports memorized. If the officer referred to certain documents, let's say telephone records that were seized, read every note, every phone call. Every time Judge Raven called Judge Gordon, every time Judge Gordon called Mr. Rose, because sometimes that will show that the theory of the Crown is wrong. And the person you're cross-examining won't be as prepared as you if you're that prepared. And your preparation will always have the upper hand. That's my advice.
I agree with preparation being the most important part of any lawyer appearing in court. I also want to thank the lawyers that appear before me, stand up, give their name clearly, spell it out, and announce their pronouns. That sets the stage for me, because it's difficult sometimes for a judge halfway into the trial to say to a lawyer, you know what, I'm sorry, I just can't remember your name. I know who you are, but I can't remember your name. So to do that every single time, to be prepared, and then to maybe give the judge a little bit of a hint or a heads up. If you have a difficult client, to say something like, my instructions are, I recognize then that you are playing the role of advocate for your client, and it may be the client taking the difficult position, and that may be easier for me to understand than the lawyer who argues vociferously the losing end of a case and is never going to be successful, and then the judge just gets frustrated.
So those are the key words to give the bench a little upfront hint that
the lawyer recognizes maybe they're not arguing the best position in the case, but they have a client that they need to advocate for.
And they're doing,
I appreciate
they're doing a
that.
good job. Yeah, sometimes you've had someone who's been released on 7 bails and failed to appear all 7, and now they're seeking bail again. Counsel stands up, my instructions are to seek my client's release. Thank you. Okay. It's a hint.
All right.
Yes.
In the time left, there's a few straightforward questions I want to ask you. Not difficult ones. Very diplomatic. What's the most challenging part of being a judge?
Oh, for me, it's when if I get a civil case and I'm unfamiliar with the law and I have to go in the back and teach myself some law.
Yeah.
I tend to agree. Fear of the unknown. It's a terrific job because you never get bored. You always see something different. But when you have a really difficult case and there may be media there and you've got really terrific counsel and then all sorts of arguments are being made and you're not familiar with the law in that area, it can be daunting.
Most frustrating?
Unrepresented family litigants who, as much as you have tried to explain your reasons, particularly when they feel it's not in their favor, appearing not to understand why you're ruling the way you are, it's very difficult.
I'm going to say the most frustrating thing for me in the job right now is dealing virtually with litigants who do not have access to MS Teams and are appearing at the end of a phone. I can't see them. And sometimes we have interpreters because they don't speak the English language. And I come away from some of those days, which should be really uplifting because they may be case conferences and they may be problem-solving days, with a headache from looking at the screen all day long and making sure that I've heard everything that everybody has said when what I'm looking at are maybe initials or a telephone number.
A modern problem.
Yeah.
It is a modern problem.
Right. Now, how often do you feel rewarded?
Oh, well, a few months ago, I off and on did a sexual assault trial where the allegation was that the accused had raped a teenage girl. I convicted him, and then she came and attended the sentencing hearing. I don't think I quoted her victim impact statement, but I, in my reasons for sentence, certainly referenced the impact the sexual violence had had on her. And the prosecutor walked upstairs after and said, she asked if she could come talk to you. And I said no, but she wanted me to thank you because she felt you had listened to everything she had said. And knowing that someone felt that, that was very rewarding for me.
What I find most rewarding is if self-represented litigants come in, for example, on a family case, and they're really angry and they're upset and they don't really know what they're doing, if we can problem solve their case through either a family management conference or a settlement conference, sometimes even though it's set for trial, I do a little bit of the informal inquisitorial method, which is being piloted right now in the interior. And then it comes to a resolution and they walk out the door happy with the decision. I find that very rewarding.
That actually is the best. I often say to people on family cases, if you go to trial, one of you is going to win, one of you is going to lose. If we can discuss this, you're both going to walk out 80% happy. And they do.
You know, that's, as counsel, one of the rewards you get is you get paid. That's something that makes you happy.
Yeah.
But there's not, I don't think there's a lot of judicial feedback, positive feedback on your decisions. I mean, there may be if it's appealed and you're upheld or otherwise, but you don't get a lot of feedback, do you?
I don't think we do at all. In terms of how we're doing the job,
Yeah.
Our decisions, if they're wrong in law, will be overturned by a higher court, or if we're right, we're upheld. But you're right about that. We don't have reviews like a lawyer in a law firm would perhaps have. They'd have an annual review or something like that.
And an increase in salary.
Yeah. We don't have that.
Yeah, we don't. And we can go. No, we don't. But we can go months and months without, working full time, and nobody knows what you've done.
I would find that very difficult, not to have somebody say to me, "That's a great judgment," or something like that.
I don't know. You kind of learn to live with it.
Yeah.
Okay. Now, I understand that both of you, this question was placed by one of the judges, by the way, I want to tell the audience. I understand that both of you are members of an elite club. And when I thought of that, I thought, was it Shaughnessy or Point Grey or Butis or Vancouver Lawn and Tennis Club or something like that? But I still don't know what it is. What's the elite club?
The University of Manitoba Judges Club.
Ah, and tell me the elite part of that, please.
Well, you have to have gone to the University of Manitoba to be in it, number one. But we have a judge on the Court of Appeal who's on it. Now, interestingly, after UBC, in our court, more judges went to the University of Manitoba than to any other law school. So we have a club. Now, 3 of our members are now fully retired. Judge Raven is on the senior program, but we have new judges like Judge Jody Harris who are coming up. So there's always people who graduated from that exceptional university getting on our bench, and they're members of our club.
Truly exceptional.
And Judge Gordon organizes all of our events. We get together on a regular basis. We talk about the good old days in Winnipeg and lots of other things.
The slush, the gray,
well,
the mosquitoes.
We're meeting soon, but it's before my trip to Winnipeg, so maybe they'll give me advice.
Here's a more beautiful thought to end this program. Judge Raven, I've heard you say that when you truly retire, you will want to obtain Italian citizenship and spend more time in the country that your father loved so much. It sounds beautiful. What's the picture in your mind of that?
Well, I can see the picture because I've been there.
Okay, I want to know the picture.
I'm working on all the paperwork. It's taken longer than I thought. And I want to go and spend a number of months, if I could, every year in the area where my parents grew up, which is a very rural area southeast of Rome, up in the Apennines, and just enjoy that kind of a life.
What wine is indigenous to that area?
Quite a bit, all kinds of wine.
Do you want me to leave that? Or?
Yeah, I'd like to know what wine is indigenous.
I have a request.
Yes.
Can Judge Gordon and I visit you there?
Absolutely.
Okay.
I don't know if you'd want to live in the 300-year-old stone house that
do.
Doesn't have any plumbing or anything like that.
We did that. I did that.
That's my heritage.
That's okay. I did that at camp. Yeah. And I do not want to go to Winnipeg to see you to retire, okay? Well, listen, thank you both for coming. I know we've known each other a long time, and we've all had a great history together, and the audience should know that Judge Gordon presided over my recent nuptials, and thank you for that. I was going to ask the question what your favorite love story was, but I didn't ask because I knew what the answer was going to be. Anyways, thank you both. It's an honor. It's been an honor over the years knowing you. It's been an honor practicing with you and being on committees with you and being your friend, both of you. And thanks all the guests. Our next show is Tuesday, February 7th, with the former mayor of Whistler, Nancy Wilhelm Morden. She was a classmate of mine. And she turned a provincial ski resort into a worldwide #1 ski destination. But she had to take into account and balance huge growth and very significant environmental and local concerns. So I look forward to speaking with her. And I end this by saying to all, good this day.
Thank you very much for inviting us.
Thank you very much.
Thank you. Thank you, audience. We'll see you soon.